మళ్ళీ చెక్ చేస్తుంది సార్.
నన్ను ఇట్లా పట్టుకోబెట్టాను. లేదు అక్కడ పెడతాను.
మోహన్ వాట్సాప్ లో ఫస్ట్ వాయిస్ వస్తుంది. నీదే కదా చూడు. సబ్స్క్రైబ్ చేసుకున్నావు ఛానల్కి? సార్ ఎవరు రాడ్స్ వాయిస్ వస్తుందా సార్? 2 minutes.
Hello. What happened?
You speak, sir, for some 2 to 3 minutes.
2 to 3 minutes I should speak. I should speak what? What should I speak? Able to hear? Hello, hello. Are you hearing me clearly? Clear? Is it clear? Not clear. Okay. Why you are looking at the screen at the same time you are looking at that side? How is it possible? Data.
Who is going to take some?
Okay, okay. Data. You will come here only by 3:60, 11:16. Then take a break. Nobody is listening, man. After third bench. Boys are super lab.
Share for him.
कितने बाजी पर जब जिला बैठ के बस
Voice Hassan. కింద పెట్టేసి
చెప్పేసి My class is 11:30. No issue. I am in the class. Class. Auditorium. I am already in auditorium. Right.
ఇది కిட்ட మై కిட்ட పోయినారు స్పీకర్ వచ్చి కాలర్ తెచ్చుకోండి తెచ్చుకోండి సార్
Richard. சரியா வரலையா வாய்ஸ்
வாய்ஸ் வரும் சார் இப்போ மாட்டாடு
which is finished.
ల్యాప్టాప్ టచ్ பண்ணாடு
நான் ஒரு லேப்டாப் டச்சே பண்ண மாட்டேன். அது யாரு அங்க திரும்புறான் யாரும் அவன் என் போட்டோவா இதா நான் திரும்பவே இல்லையா அப்படியா எடுக்கலாமா கிளாஸ் ரைட் ஹலோ யா ப்ளீஸ் செட்டில் டவுன் ப்ளீஸ் your last benches please settle down. You are all good students please. வைவால மார்க் வேணுமா வேண்டாமா வேணும்னா லெசன் கேட்கணும். We have to hear the lessons now. Right. I am going to deal with ADR, alternate dispute resolution. It is another important subject for you. Please last bench enna. Yes please. Right. Shall I start? Yes. ADR is another important subject for you, that is alternate dispute. Last bench Annamama, please sit down. Alternate dispute resolution. Let's go into the genesis of ADR. Genesis of ADR. So normally what happens, suppose when there is a civil suit where you are going and filing the civil suit in the civil courts, right? Now what happens normally, if you go to the courts, file the suit, it will take minimum 3 years, 4 years, 5 years, right? Then after even getting the decree also, you can go for appeal, special leave petition, or whatever it may be. These are the various forms, right? Now subsequently, to avoid the litigation, to avoid the time involved in resolving the dispute, you are resorting to one mechanism that is known as alternate dispute resolution. It's a very technical subject. It is not what you think of simply mediation, conciliation. It's not like that. So here, yeah, please, last, please listen. Please settle down. Right. Now, you know the constitutional right. Delivery of justice is your fundamental right in the Constitution. Delivery of justice is your fundamental right in the Constitution. Right. Now, delivery of not only justice, delivery of speedy justice is your fundamental right. Here what happens? You are going to the courts, traditional method of filing the suits, it will take lots and lots of time. So now what the legislature has intended, that there should be a speedy justice for the parties. Speedy justice for the parties, that too, that should be inexpensive. If you go to the courts, what happens? You are going and filing the court fees. You are going, and the court has to follow the procedural aspects. Enna procedural aspects enna court வந்து CPC follow பண்ணனும், court வந்து evidence act follow பண்ணனும். இதெல்லாம் follow பண்ணி இவన్నీ follow చేసి லாஸ்ட்ல உங்களுக்கு ஆர்டர் கொடுக்கறப்ப என்ன ஆகும்னா, it will take more time, right? Now the legislature means our government has intended there should be some sort of speedy justice to the public litigants. So they thought of one mechanism that is known as alternate dispute resolution. That means they are resolving the dispute that has been entered into between the parties. You hear one thing, For example, court is there. Court is there. Court has passed a decree. Enna decree anna? Favor of plaintiff. I want exact definition from you. Decree and judgment. What is meant by decree? It's a formal expression by the courts. Formal expression by the courts. Judgment is the reasons given by the court. Right. Now, this alternate dispute resolution operates in different arena. Traditional courts operates in different arena. Court has passed a decree, right? For example, one person is having a decree. He went to another person. He told that I am having a decree in my hands. Then he will say, hold the decree, keep in your pocket, go to home. Yes. Decree follow up on a rule irka? Rule illa. Next time enga pannona? EP file pannona. He has to go and file the EP. Now here, in alternate dispute resolution, also a type of decree is passed. It is known as deemed decree. In alternate dispute resolution, order has been passed. That order is known as an award. It is known as a deemed decree. For example, two persons are there. A is there, B is there. There is some dispute between A and B. Right. Now, they went to arbitration. Arbitration, an award has been passed. Who has passed the award? Arbitrator. Arbitrator has passed the award. Who is he? He is not a court. He is not a court. Arbitrator means who? It's a private individual. He is not a court. He has passed one order. Now, you are having the order passed by the arbitrator, that is known as an award. அது என்ன சொல்லுவா? ஆர்பிட்ரேட்டர் பாஸ் பண்ண ஆர்டரை அவார்டுன்னு சொல்லுவா. அவார்ட். இப்போ உங்க கையில் அவார்டு இருக்கு. Right. Now you went to that person. Arbitrator has given me award in favor of me. Please obey of what you tell. Court order pass பண்ணாவே நான் ஃபாலோ பண்ணல. நீ யாரோ ஒரு థర్డ్ పర్సన్ ఆర్డర్ கொண்டு வந்து అవార్డ్ అని சொல்ற, ఎవరో కూడా పాస్ చేస్తే అవార్డ్ అని చెప్తున్నావు. How I am going to follow? I don't follow this award. Now, this award can be questioned in the court of law as a EP. You understand? This award is nothing but a deemed decree. You understand? Now, why we are going to alternate dispute resolution not without going to the courts means, first one is speedy justice. Speedy justice. Second one, it is less expensive. Less expensive. Third one is within short period of time, your disputes is likely to be adjudicated. Right. Now, we are having basically two acts which govern this arbitration procedure. ரெண்டு சட்டம் இருக்கு நம்ம கையிட்ட. One is Arbitration Act 1940. First act is Arbitration Act 1940. Right. That has been. Second act is Arbitration and Conciliation Act 1996. Arbitration Conciliation Act 1996. Remember, ADR also there is likelihood of failing you. Professors are failing in ADR also. If you write cock and bull stories, remember 1.5 years will wasted for you. ADR such a simple subject. Two acts which govern the arbitration in India is Arbitration Act 1940, Arbitration Act and Conciliation Act 1996. Right. Previous act is there. Arbitration Act 1940 is there. Here, two defects are there in this act. In which act? Old Act. 1940 Chattathila, two defects are there. One is excessive judicial intervention is there. Old Act. I will tell you what is meant by judicial intervention. Excessive judicial intervention is there under Old Act. For example, A is there, A is there, B is there. Two persons. There are two dispute is there between A and B. Right. Now, in the contract itself, you have entered into one agreement. If any dispute is there, we will refer the dispute to arbitration. Contract frame pannum bode, whenever you are framing the contract itself, there is one clause. If any dispute arises, we will go to arbitration. This may be in the main contract, or you can frame a separate arbitration contract also. That is your wish. Right. Now, there is a clause in the contract. If any dispute is there, we will go to the arbitration. Right. Now, there is A and B is there. There is a dispute between A and B. A wants to go to arbitration. Right. A went and filed an application in the arbitral tribunal. Right. A went and filed application in the arbitral tribunal. That means arbitrator. Now, B don't want to go to for arbitration. Immediately what B is going to do? B is filing a suit. B is filing a suit and the court is passing an interim order not to proceed with arbitration. You understand? That means judiciary is interfering in the arbitration procedure. A wants to invoke the arbitration, B don't wants to invoke the arbitration. B is going and filing a suit, court is staying that arbitration. Judicial intervention is there. In which act? 1940 Act. Right. This is first defect. Judiciary enna panna? Nee arbitration move pannadan solle interim injunction kodukom. Stay kodukom. Arbitrator don't follow with the case. Stay. Second one, Arbitration Act 1940, it is not recognizing the foreign awards. Foreign awards, for example, two companies are there. For example, take Infosys. Infosys is in India, Infosys is in America. There is a dispute arise between Infosys in America. America company go for arbitration. American arbitrator has passed an award in favor of American company. Now, that foreign award is enforceable in India also. Foreign awards, we have enforceability of foreign awards and CPC. Foreign awards. Old Act, 1940 Act, it is not recognizing the foreign awards. Which Act? 1940 Act. Two defects are there. One is judiciary will repeatedly interfere in the arbitrator procedures. Second one, there is no recognition of foreign awards. Now, to overcome these defects, new Arbitration and Conciliation Act 1996 has come into picture. Here, judiciary has very restricted role to interfere. Once you go under Arbitration Conciliation Act 1996, judiciary cannot interfere only in respect of certain matters only. It cannot stay the proceedings. Proceedings stay panna mudiyadu. Iduvulla new act ke 1996 act ke ya. The basic premise of arbitration is what? Speedy justice. Now, if the court interfere and stays the order, what happens to your fundamental right of speedy justice? It is, yes. Now, this is one aspect. Judiciary role is very, very restricted in New Act, 1996 Act. Second one, 1996 Act recognizes enforcement of foreign awards. Enforcement of foreign awards also it recognizes. Now, this new Act 1996 is based on one model law. ஒரு law மேல base ஆச்சு. Our arbitration conciliation act is based on one model law, that is 1985 UN Citral, United Nations Commission on International Trade Law. என்ன சொல்ல வார்த்தை? UN Citral, UNCITRAL, United Nations Commission on International Trade Law. We are signatories to that convention. Now we have adopted the model law based on UN Citral model. Our Arbitration Conciliation Act is based on which model law? UN Citral model law. Adu mela base aayirukku. That is model law. You know why? We are having International Center for Commercial Arbitration. If there is dispute between two countries can go for arbitration. Enga pononna ICC ku ponom. ICC anna International Cricket kadiyadu. International Commercial Court. They will arbitrate. Again, it is based on UN Citral model. You understand? If there is dispute between two countries can approach under UN Citral, International Commercial Arbitration Center. Now, you know the basic idea behind alternate dispute resolution. Enna? Speedy justice, less expensive, plus less formal requirements. Arbitrator need not follow CPC, arbitrator need not follow Evidence Act, nothing is followed, simply he will pass. Now, for the purpose of convenience, arbitration is classified as two types. First one is consensual and amicable. Consensual and amicable. Enna consensual anna? Consensus ad idem, identity of minds. That means consensual means two parties will agree and they will go for arbitration amicably. That means consensually both parties, A is going to agree for arbitration, B is agree for arbitration, they go before arbitral tribunal, they get the award, they will follow the award. They will follow the award. This is first classification, consensual and amicable. Second one, non-consensual and adversarial. Adversarial. Non-consensual and adversarial. That means whether you like it or not, the matter is referred to arbitration. Arbitration. There, adversarial means they will light your evidences. Arbitration pona out ennagum theriyuma, unga evidences ellam kuda wait பண்ணுவா. They will go into evidences also. Who? The arbitral tribunal. Whether you like it or not, going for arbitration. There, adversarial. First case, both parties accept the award. Second, whether you are going to accept or not, award is passed. That is known as consensual and adversarial. Right. Whether you accept it or not, award will be passed. If you don't accept that award, subsequently you will be having your remedies. award can be challenged subsequently. இப்போ என்ன பண்றேன் நான் அவார்டு பாஸ் பண்றேன், உனக்கு பிடிச்சா ஃபாலோ பண்ணு, பிடிக்காத போனா நீ அப்பீல், you go for your remedies are there. First is consensual, we both accept. Second one person is accepting, another person is not accepting, right? Now in this process, in this alternate dispute resolution process, there are some processes are there. First process is determinative process. Determinative process. Determinative process. Here, what is determinative process means? The arbitrator will evaluate the dispute. He will evaluate the dispute in the light of evidences. In the light of evidences, he is going to evaluate your dispute and passes an award. இங்க என்ன பண்ணுவான் ஆர்பிட்ரேட்டர்? both parties ஓட எவிடன்சஸ் எல்லாம் பார்ப்பான். எவிடன்சஸ் எல்லாம் பார்த்தா விட்டு he will resolve the dispute. That means he is determination of your issues are there, right? Coming to second process, it is a facilitative process. Facilitative process, that means that neutral enna arbitrator, in the language of arbitration, neutral we call arbitrator neutral. That means he is neither side. Neutral enna எந்த பக்கம் இருக்க மாட்டான், அவன் என்ன சொல்லுவான்னா நியூட்ரல்னு சொல்லுவான். ஃபெசிலிட்டேட்டிவ் ப்ராசஸ்ல அவன் என்ன பண்ணுவான் தெரியுமா? அவன் டிட்டர்மைன் பண்ண மாட்டான். he don't determine your dispute. He will facilitate you to come to a conclusion. He will ask you, you please go through this. He will merely facilitate and he makes you to arrive at a consensual decision. He don't determine your dispute. Determine பண்ண மாட்டான். ரெண்டு பேரையும் உட்கார வச்சு என்ன பண்ணுவான் தெரியுமா? நீங்க இந்த டெசிஷனுக்கு வாங்கோன்னு சொல்லுவான். டெசிஷனுக்கு வாங்கோன்னு சொல்லுவான். First thing is determinative process comes under arbitration. Facilitative process comes under mediation, negotiation, conciliation. Mediation, negotiation, conciliation. இங்க first partல என்ன பண்ணுவான் ஆர்பிட்ரல்? award is passed. In this second, there is no award. It is only a consensual acceptance. He merely facilitates you. He makes you sit, please do this, or understanding வாங்கனீங்கோ and சொல்லி கேட்பான். This is third type of process is hybrid process. It's a combination of both. First, they will ask you to mediate, conciliate, negotiate. அது fail ஆச்சுனா arbitration. That is hybrid process. First you go for mediation, conciliation, negotiation. If it fails, then go for arbitration. That is known as hybrid process. In terminology, that is known as med-arb. MED, med, hyphen, arb. Mediation come arbitration. Med-arb process. Med-arb process. Med-arb, MED hyphen ARB. Med, that means mediation, arbitration. Right. Till now, we have analyzed the genesis of arbitration. What are the two acts which govern the arbitration? One is 1940 Act. We have seen two defects in 1940 Act. One is higher judicial intervention. Second one is non-recognition of foreign awards. Subsequently, another act was passed, that is 1996 Arbitration and Conciliation Act, that is based on 1985 UN-Citral model, and we have seen the process: determinative process, facilitative process, hybrid process. Right. Now, apart from this, there are two broad categories. Two broad categories of this ADR. One is court annexed options. Court annexed options. And second one is private ADR mechanism. Court annexed options means it is pertaining to the courts. Court annexed options. Right. Second one is private ADR mechanisms. Now, court annexed options means you are going to the court. Court, for example, under Family Courts Act or under Marriage Act, you apply for divorce. Divorce. Now, what the courts are going to do? First, go for conciliation. First, என்ன சொல்லும் court? Straight away divorce கொடுக்காது. Counseling போனோம். That is mandatory. Court annexed options are there. Now, for example, under Industrial Disputes Act, where you have to go and file the case, labor courts. Labor courts. If you take Industrial Disputes Act, labor court labor court will tell go for mediation conciliation first under Industrial Disputes Act. If mediation conciliation fails, again you come to labor court, I will pass award. These are known as court annexed options. First, court will ask, go for arbitration, go for mediation, go for conciliation. If it fails, I will adjudicate the dispute. Next one is private ADR mechanisms. Private ADR mechanisms means it is basically commercial arbitrations, which is normally in contractual agreements. Private ADR mechanisms. International commercial arbitration, you are going for arbitrator. These are known as private ADR mechanisms. Court annexed options, private ADR mechanisms are there. Now another classification is there, whether it is binding or non-binding. Binding or non-binding means what? Whether you have to obey or disobey. Depends upon the nature of binding or non-binding. Again, ADR can be classified. Arbitral award is binding. Arbitral award is binding. Mediation, conciliation, negotiation, இதெல்லாம் bind கிடையாது. நீங்க அதை ஃபாலோ பண்ணணும் ரூல் கிடையாது. ஆர்பிட்ரல் அவார்டு மாத்திரம் என்ன பண்ணணும்? ஃபாலோ பண்ணணும். ஃபாலோ பண்ணலன்னா நெக்ஸ்ட் ரெமெடி என்ன? If you don't follow the arbitral award, what is next remedy? Execution. Why? It is a deemed decree. You understand? Understand the technicalities. Or the decree mari atta nanchikono. Straight away you go and file EP, enforcement petition, execution petition for enforcement of that award. That is binding on you. Whereas mediation, conciliation, negotiation, they are not binding. They are not binding on you. நீ கன்சிலியேட்டர் எதனா ஒன்று சொன்னா நினச்சிக்கோ, அத்தை ஃபாலோ பண்ற கிடையாது. நீ ஃபாலோ பண்ணலாம், ஃபாலோ பண்ணாத கூட போகலாம். ரைட். நவ் Another classification is mandatory process, voluntary process. Mandatory process and voluntary process. Mandatory. That means that is mandatory. Yes, in marriage settlements, mandatorily court will refer to conciliation. Voluntary means section 89 of CPC. Section 89 of CPC, there is one provision is there. If both parties accept for arbitration, the suit can be referred to arbitration. Section 89 of CPC. First one enna mandatory. Compulsory court anna pannano arbitration conciliation ka anpano. Voluntary anna parties ottundada anpano. Section 89 of CPC says if both parties accept for the same dispute can be referred to arbitration. Arbitration. Now you have understood the meaning of arbitration. It is a private adjudicatory process. It's a private adjudicatory process. What is the meaning of adjudication? What is the meaning of adjudication? Court proceedings illa adjudication anna one person will adjudge your case. One person will adjudge your case. Private adjudicatory process, that is in arbitration. While coming to mediation and conciliation, it is non-adjudicatory process. He never adjudicates. He will make the parties, he will arrive the parties to a amicable solution. Arbitration enna pannuva? Avan panna evidences எல்லாம் பண்ணியான் எல்லாம் பார்த்து அவார்டு பாஸ் பண்ணுவான். மீடியேஷன் கன்சிலியேஷன் என்ன நடக்கும்? ரெண்டு பேரையும் உட்கார வச்சு ஒரு செட்டில்மெண்ட்டுக்கு வாங்கன்னு சொல்லுவான். He never adjudicates. He never adjudicates your claim. Arbitrator will adjudicate your claims. Right. Then negotiation, mediation, it's nothing but the mediator or conciliator, he never adjudicates your dispute. He plays an interventionist role. Interventionist anna who interferes. Who interferes. He plays a interventionist role. Right. So alternate dispute resolution mechanisms means arbitration, mediation, negotiation, conciliation. Now another type of thing is there that is known as lok adalats. What is the meaning of lok adalat? People's court. People's court. It is non-adversarial system. Non-adversarial system. The basic premise on which lok adalat is going to come is compromise. Enna panna? Compromise chestundi. It is going to compromise state authority, district authority, then Supreme Court Legal Services Committee, High Court Legal Services Committee, Taluka Legal Services Committee. So many committees are there. They are nothing but lok adalats. Now, what is the basic object of lok adalat? Compromise. Right. Now, again, Compromise means they don't compromise everything. எல்லாமே compromise பண்ணுவாரான்னா பண்ணக்கூடாது. You don't understand? Compromise means, for example, A is there. A is there. A stabbed B. A என்ன பண்ணா? Stab என்ன? கத்தியில குத்திட்டான் அவனை. சொருகிட்டான். Right. Tamil language அது. Right? Now A stabbed B. B died. B died. Case has been filed. Now A is coming, B's members are there, they come. Let's compromise. A is telling, I give you some amount to you, let's compromise. We will go to Lok Adalat. Lok Adalat podamo, compromise ayipodam. Yes, Lok Adalat says it cannot be compromised. Compromise panna mudiyadu. That means only non-compoundable things can be only compromised. Understand? Only non-compoundable offenses. எல்லாமே compromise பண்ண முடியாது. Non-compoundable offenses என்ன? What is the meaning of non-compoundable offenses? If you pay fine, your offense will, that your punishment will be, and you nullify. Substitution. If you pay fine, your punishment will be substituted. Fine pay cheyachu. Fine traffic rules undi. Traffic rules పాటించలేదు అనుకోండి, అప్పుడు ఏం చేస్తారు? ఫైన్ వేస్తారు. You know why? Petty offenses are compoundable. Petty offenses are compoundable. You can pay the fine, you can come out. Compoundable offense. For example, you are having a hen in your house. Henna koi. Yeah, seva koya, or koi. Right. You are keeping so many things to hen that nalla valathirukanga, badam paru pot ellam paru, hen is going like this big thing. Your neighbor wants to eat that hen. It's a big, like good thing. One day you went to somewhere, he ate that hen. You filed a case against him for theft. Then judge will call. Yes. It's a compoundable. Yes. ஏன் தெரியுமா? உன்னை ஜெயில வச்சா நினைச்சுக்கோ, மார்னிங் டிஃபன் கொடுக்கணும், மத்தியானம் சாப்பாடு போடணும், ராத்திரி டிஃபன் கொடுக்கணும், சண்டே சிக்கன் கொடுக்கணும், மட்டன் கொடுக்கணும். எல்லாம் கொடுக்கலன்னா ஃபண்டமெண்டல் ரைட்ஸ் வயலேஷன். Yes. So compoundable. Yes. You can do what is called strike in jail. Strike in jail. எனக்கு சிக்கன் கொடுக்கலாம், ஸ்ட்ரைக் பண்ணலாம் ஜெயில. Yes. அப்புறம் அவங்க வேற கொடுப்பாங்க போலீஸ்காரா. போலீஸ்காரா அப்புறம் வேற கொடுப்பாங்க, அது வேற விஷயம். புரியல? எஸ். ரோல் கால் கூப்பிடுவாங்க, அப்ப கொடுப்பாங்க எல்லாம். ரைட். அது எப்படி தெரியும் கேட்காத, நான் எப்போ ஜெயிலுக்கு போகல. ரைட். ரைட். Now only, yes, it can be compromised. Here there is no court fee, there is no court fee, there is no rigid procedural requirements. Court fee kadiyadu, there is no rigid procedural requirements. That means legal service. Have you seen any decree for compromise? They will put only 3 lines. Decree for compromise irukum pathia, divorce decree la. Wife and husband, they don't want to join together, hence divorce has been granted. Now henceforth they are not wife and husband. That's it. Only moonline decree தான் கொடுப்பாங்க காம்ப்ரமைஸ்ல எல்லாமே. They don't go into the rigid things. In traditional method, they will evaluate all the evidences. This is one aspect. They need not follow CPC. They need not follow Evidence Act. Here, parties can directly interact with the judge in the trial process. Where? In Lok Adalat. Judge will be sitting there, you will be standing there. You can talk to judge. It's merely an informal process. Judge pesalam. You know, Lok Adalats, no lawyers will come in the dress code. All will be in normal, informal dress only. Judge also sits in informal dress only. He will ask you. You can talk to the judge. You can interact with the judge. Subsequently, if there is a consensual agreement, he will possess a compromise decree. So, Lok Adalats are another ADR mechanism. Now, not all disputes are arbitrable. Ella disputes, anni disputes arbitration ki veltunda ante velladu, vellakudadu. So, criminal offences, non-arbitrable. Criminal offences are non-arbitrable. Yeah, please listen. Criminal offences are non-arbitrable. Fraud, non-arbitrable. You cannot refer fraud to arbitration. Right. Now, disputes between patent, trademark, copyrights, non-arbitrable. Disputes between patents, trademark, intellectual property rights, it's non-arbitrable. Next, antitrust or competition laws. You know competition laws, regulatory laws, Competition Commission of India, antitrust laws. They are also non-arbitrable. Right. Next, matrimonial disputes, non-arbitrable. Matrimonial disputes, non-arbitrable. Consumer disputes, non-arbitrable. That means you cannot refer fraud, you cannot refer matrimonial disputes, you cannot refer consumer disputes, you cannot refer these competition laws. Even insolvency petitions cannot be compromised. Insolvency also, it cannot be, yes, insolvency disputes also cannot be referred to arbitration. Right. Now you have seen, you will be having one question on this. Non-arbitrability, they will ask one case law in you. What are the disputes which are non-arbitrable? Right. Now, there are certain terms you have to know in the arbitration. Terms. First one is tribunal. Tribunal means arbitral tribunal. It includes sole arbitrator. Even one person is there. He is a sole arbitrator. He is known as tribunal. Next one, award. Award means binding decision of the arbitral tribunal. Binding decision of the arbitral tribunal. Next one is seat. S-E-A-T. Seat means place or venue of arbitration. Place or venue of arbitration. Place or, you know, place or venue of arbitration is very, very important. You know why? If you want to challenge the award passed by the tribunal, The place is very, very important. At what place you want to challenge the award? So the place is very, very important. Right. Next is arbitrability. Arbitrability means subject matter of the disputes. Right. Now, arbitral decisions or decisions, they are what is known as decisions in persona, but not in rem. You know the meaning of persona and rem? Yes. These decisions are binding only in persona, only two persons. Whoever goes to the arbitral tribunal, the decision is binding on only those persons only, persona, but not in rem. Rem means against the whole world. Against the whole world. Arbitral decision is binding on only on the parties involved in the arbitration. Right? Tomorrow we are going to see how you are going to enter into arbitration agreement, contents of arbitration agreement, and remaining parts. Got something today? Right.
Have a good day, guys. Myself Shubhamastu, and yesterday we have discussed about the what is crime, definitions of crime, elements of crime, and stages of crimes. Today we are going to discuss about the dimensions of crime. That means which is resulted a crime. Basically, a crime has two dimensions. That means one, it has a sociological, and another one is economic. In social dimension, age, class, caste are the important things. Same as there are differentiation in economic also. How age, class, financial status is be a cause to the crime is our today's topic. So one thing that is which comes first, at when what is a person start to or commit a crime? Most peak period is 8 to 12. That means early teenagers. When a child enter to the world of crimes and he reach the top at his late 19 or teens. That means 15 to 19. After that time, some of them are decent or take out of that criminal world. But that time when he entered and when he in his top is the very vital time when we can take him out from a criminal world. So why at that so early as a person start to enter into a crime? When there is a study, it says that some do it for their enjoyment. Some says that for their financial status. Some says that they want more. That's why they enter to the to this criminal world. And that is the true thing. If you think as a rational person, it is the fact when a child, when he compares himself from other, as a human nature, we have that tendency, we compare ourselves who is better than us, maybe in financial, maybe in everything. And the children has or teenagers has that tendencies much more than an adult. That's why they enter into the criminal world. Some do for their enjoyment or they get pleasure from that crime. If you have go through that Nirbhaya rape case, that teenager, he has no intention, he has do it only for the enjoyment. That's these factors which makes a child or as a boy or girl or whoever it is of a tender age to enter into a criminal world. Second, distinction, maybe on religion, maybe on caste, maybe on anything, financial status. It leads a person to enter into a, when you suppress a particular group for many years, it makes or think like a criminal. They have developed that tendency. I think you guys have heard that about my castle, my rule theory. Yes or no? So in that theory, whose place is that? The place is belongs to whom? Rule is of his. So this place now belongs to me. And I have only one rule. Those who don't want to be here, please leave the class. And you have 2 minutes only. And if you want to be here, be here. Then come to class system. So in society, we know that upper class, middle class, lower middle class, and lower class. Why that class system was developed? Due to our financial status. As I told you, if someone has a car, I want to buy a car, because we as a human, we have a tendency to compare ourselves who is in front of us, who are better than us. He has a car, I want to also buy a car. He has this thing, I want to also that thing. That class system also a main factor of our crime. So like that, race, caste, religion is also have the power which or anything that what differentiate us from other human being that creates a criminal. Basis of financial status, basis of religion, basis of caste, basis of age also. It creates a criminal. So this is the social dimension of the criminal crime. Now come to the financial or economic. So most probable, if you heard about Nirav Modi, Vijay Mallya, who are they? They are the economic criminals. They organized a group, make some financial disturbance of the country, take amounts and leave the country. There are full of cases regarding these things. Harshad Mehta case, stamp, vending stamp case, now 2G case, coal mine case, everything they are comes under the this economic crimes. So what is the effect of that things? Economic crisis like inflations, cash deficits, so other things. Yes or no? So that are the economic aspect of the crime. Yes, sir. In economic, what basic factor is what in social criminal crimes, or what is the social dimension of a crime, where you have differentiate yourself from others by name of whatever there is. Yes, you have a better phone than me and I have want that phone, latest model of Apple, iPhone 14 Pro Max. I don't have, you have, and I want that. So I cannot afford that, so I theft it. You have a car. Yes. Wherever you differentiate yourself, others, and you want to be in that place, and it creates that mentality to get that by any way. There you create a criminal intention to get that thing. By theft, by robbery, by any hook and crook, you want that thing. That is the social aspect, social dimension of that crime. Economic, also like that. Basically, that white collar crimes. When you want that amount of money, like they all do, that creates an economic offense or economic dimension of that crime. Yes. So the basic, or what why I want to try to say that crimes are always with us like mosquito. We cannot eradicate that thing. But what we can do, we can find out when it is, or what is the basis of creation of a crime, or when a criminal is going to commit that crime, or where that criminal is going to commit that crime. If we know that things, or our state know about that things, only that case we can control it. Yes or no? So these things are important. That means what is the cause for a crime, dimensions, who is going to commit that crime, or who is affecting due to that discrimination, that differentiation. We have to control that thing. where that crime is going to happen, the place. If we know about these three things, we can control the crime. Another thing to control it, to report it. To whom we should report it? To states, state head agencies to investigate, to control the things? Yes or no? So first, where we report the crime? In police station, or in second one, in the court. So how we report a crime in police station? By FIR. 154 CRPC. So 154 CRPC says you have to report that offense or give information to a police officer. The offense should be a cognizable offense. It is either in written or in oral. This is the affair, right? And by that way, we can report that crime to a police. And after that, there are investigation, trial, whatever there is. Second, or from this point, another question arises. Do we have to be present in the police station to report that thing? Or we can call to police station to report a crime? We can call also. That means telephonic affair. But Supreme Court, in the case of Jessica Lal murder case, that Basist versus Union of India. So in that case, most popularly known as Jessica Lal murder case. In that case, what Supreme Court says? Whenever you are giving a message or affair, lodging an affair in the telephonic message, it should be clear. It not in the cryptic manner or void. It should be clear. Then only it is treated as an affair. So we can call a police station to report an affair also. So this is when we are in the police station. 154 says you have to go to police station, write a report to a police officer. If he is not taking that affair or not lodging that affair, in that case, second point, to SP, higher authority. If SP is not taking your affair, yes, report to the court under section 200 of CRPC, which is popularly known as complaint case. So we have a recourse. If police is not taking our affair, we can file a case or we can report it to the police station also. Court also under section 200 in the name of complaint case. So there are provisions where under section 156 subsection 3, court has given order to the police to investigate that thing. So this is three things where we can report. Now it is a new. Can we email the affair to police station? Yes, online. Yes, in different states there are portals regarding online complaint which is connected to the police station and police has to. So in online form also we can report a case to police. But if you see the statistics, NCRB statistic, National Crime Record Bureau, does these things are happening properly? If some lakhs of cases still pending in the court, police stations they are not taking or they are not investigating the cases properly. So in that case, our crime crime rates are decreasing or increasing. So we need our judicial system, our investigating system should be that efficient to carry out or to investigate all this, dispose of all these things. So, okay, that if that things also happen, but there are some hindrance where proper reporting to the police station or to the concerned department is not happening, which is also a point when our system is not work properly. What are they? Social status, social stigma. If there is a case, we first think who is going to that places, police station, court, we don't want to mingle with that things. We have a social stigma to go to police station. In very popular example, take the rape cases. That victim does not or she don't want to face the court, police because of their treatment towards the victim or that lady. Sometimes the amount of our loss is so minimal that we don't want to complain it. If someone take your shoe, who is going to file a case? We don't want to. We just don't report it. Like that. Sometimes in accident cases, you want to report that thing, you want to help the victim, but we have that afraidness that police may involve us in that case or may file a case against us for that accident. So these are some things where we are not, or the reporting of the crime is not happen in that way how it should be happen. So how the cases crimes are reported? By 4 ways: directly going to the police station, by telephonic, if there is not recourses, we are go to court. New aspect is online things. So by that, and the problems where the proper reporting is not happening to the our system. Yes or no? Now comes to the crime rate. That means what is the rate in every 1,000 of population, or in a particular manner a million of population, what is the rate of crime? So for different offenses, if you go to the latest 2021 NCRB reports, in comparison to 2020, there are an increase in the number of crimes in our society per million of population. What is the main reason of that increase? Yes. So the factors, what depends the increase of the rate of crime in our society are territory, population, heterogeneity, and our values. So first come to territory. If you go to the statistics, in some state the crime rate is more than some others. If you collectively saw India, Bihar, UP, Punjab, that region, and here Maharashtra, the crime rate is little bit more than ours. Why? Population constraint. That is our second point. But the main factor is population. Why? Yes, scarcity of everything. We need it. Where there is the density of the population, you find out there is the place where crimes may be committed. For take example of any tourist place of a town, the crime rate is little bit more of theft, robbery, whatever is more in that place, in that crowd, because criminals find out a very good hideout in that dense population. Second is, he says, scarcity of everything. We need everything. We need every happiness. We need everything what we don't have. So in the urban area, on township, the crime rate is more than in the rural area. And because in the village they don't have any ambition to get that thing, but in township, in urban areas, they want everything by any way, hook or crook. So that is the second thing. Third one, heterogeneity. As I told you earlier, differentiation. Differentiation in class, differentiation in caste, differentiation in religion creates the criminal, or it creates a very good place for the criminals. We are not less than others. That is the main reason. Our group is not less than other. We are superiors. Other are not. That creates the criminal mind or criminal intention. Yes, that thing goes. You are. So this ethnic classes or group classes is the main factor, as population as territory is another fact which increases the crime rate of our society. Last one, our values. Basically, the religion. Prior to independence, we are fight with each other. I am Brahmin, I am Kshatriya, I am Shudra. We are fighting on the caste. During the process of independence, we fight with each other with the name of religion. I am Hindu, I am Muslim, I am Christian. And which is still continuing. But every religion has one motto, that is love. In Hinduism, we called it Paragyanam Brahmam Atma, Ayam Atmam Brahmam, Aham Brahmasmi Tat Tvam Asti. Brahma was the knowledge. I am the Brahma. What I am, you are also that. That means Brahma. We all are equals. Same thing says in Muslim or in the Mohammedan religion also. उसी ने ही सबको बनाया, हम सब एक दूसरे के लिए हैं. So every religion has the only one true value that we are all equal. We don't have any discriminations. But for our personal gain, some peoples make it a business or treat these whole things as a business of crime by classing each group. So that these 4 points are the main factors which increases the crime rate of India. After that also, there are different factors which, like our sex ratio, ethical ratios of or the places some migrants ratios are also depend on the increase of the crime rate in India. Like Maharashtrians don't allow the Biharis, Jharkhandi to enter into their places. Some peoples from here don't allow to enter into the some other places. Northeastern peoples are treated as a Chinese in NCR class region. So this migration also, or that not acceptance of our own people, is also a factor which increases the crime rate in our society. Yes or no? So, for any questions? Nothing? So for today, this is all. Next class, we are going to discuss about the crimes of powerfuls. That means white collar crimes and other things which are there. Thank you and have a good day, guys. But wait for your attendance. Don't leave the class right now. What happened? It's good.
Listen, like yesterday itself, 5 year LLB, BA LLB will go to room number